Gâlea, who is a lecturer of law at the Department of International Law at the School of Law at the University of Bucharest, and also the Director General of the Legal Affairs at the Ministry of Foreign Affairs of Romania.
Professor Motoc, Professor Boisson de Chazurn, dear colleagues, professors, I have chosen a topic linked to a fairly new phenomenon, meaning that 15 years ago the general practice, at least in Romania, was to conclude a basic political treaty with each state that would represent the ground basis of the bilateral legal framework. Today, this is not anymore the same. The practice is to conclude documents entitled Declaration, Action Plan, or Memorandum of Understanding. Are these documents simply political commitments without any consequences in international law, or do they have any legal effect? Moreover, do these documents have any consequence in domestic law? I have proposed to explore a little this difficulty and to focus on case law of the International Court of Justice, different opinions in the doctrine, and third, the practice of Romania. The International Court of Justice was generally very liberal towards the notion of treaty, meaning that upon meeting the simple criterion that the text demonstrates the will of the parties to create rights and obligation, legal effect was granted. For example, in Aegean Sea continental shelf case, the court stated that on the question of form, the court need only observe that it knows no rule of international law which might preclude a document called joint communiqué from constituting an international agreement. In another case, maritime delimitation and territorial questions between Qatar and Bahrain, the document was entitled Minutes, and inter alia provided that it was agreed that the two parties may, at the end of a certain period, submit the matter to the International Court of Justice. Usually minutes are concluded after a negotiation takes place. The court put an emphasis on the word agreed and concluded that the minutes are not a simple record of a meeting, but they constitute an international agreement. Moreover, in the Temple case, Cambodia versus Thailand, the court ruled that the acceptance of a document determines that it becomes a party of the treaty settlement of a border, even if the treaty was not even signed, that document was not even signed. The most relevant aspect was the total lack of formal conditions. An argument by way of analogy is linked to the nuclear test case that concerned, that acknowledged that unilateral declarations concerning legal and factual aspects may have the effect of creating legal obligation. If an unilateral act made public may produce legal effects, we would see no reasons for a bilateral or multilateral act in the form of a declaration to have similar legal effect. I wish to refer briefly to certain controversies in the doctrine. For example, one opinion is expressed by Professor Jan Klabbers. He rejects the claim that states could conclude agreements binding from the moral or political point of view. He assumes that understandings concluding between states and international organizations, which have a normative nature, meaning that try to influence the future conduct, can be only treaties, meaning, in his opinion, intention can refer only to intention to commit legally, not politically or morally. On the other side, Anthony Ost uses the term memorandum of understanding in a generic sense to define instruments concluded by states that they do not intend to submit to international law or any other law, and in consequence are not legally binding. On the basis of sovereignty, states decide that they do intend to assume a politically binding commitment and not a legally binding one on the basis of the deliberate and careful choice of words. In the practice of Romania, I have noted an important number of documents entitled Memoranda of Understanding, and their analysis reveal the following pattern. They are, most of them, in the form of a treaty, meaning that they provide that the parties have agreed, they enter into force, and a significant number of them follow the domestic procedure of approval by the government and publication in the official journal. However, the substance does not provide for hard commitments, meaning that the so-called obligations refer to cooperation, consultation, exchange of experience. The diluted nature of these obligations demonstrates that, in fact, if the commitments were political, there would have been no problem. But I want to draw the emphasis on one phenomenon. Why are memoranda of understanding important today? For example, if a Romanian producer wants to export meat to China, the Chinese authorities would require an agreement on sanitary veterinary cooperation. This is not possible to be concluded anymore because sanitary and veterinary cooperation is part of the common commercial policy of the European Union. And if Romania would have concluded such a treaty, it would have breached Article 351 of the Treaty on the Functioning of the European Union. But if Romania would have concluded a memorandum of understanding stating that the parties understand, they commit to recognize sanitary veterinary certificates with direct implications over the business of producers, this document would have the effect of facilitating trade, but in fact would not be a legally binding document. However, can such a document have effect in a domestic court, either in Romania or in China, in the relation between the two traders? Another important pattern in Romania is the practice represented by the so-called declarations adopted on the highest level, heads of states or government, that are in the process of replacing the former basic political treaties. An essentially political document is, for example, the Joint Declaration on the Strategic Partnership for the 21st Century between Romania and the United States, and of 2011. The text of the document is so carefully drafted that hardly could we read any legal commitment. However, I wish to quote a provision in the Joint Declaration between Romania and China of 2004. Its form is the form of a political document, but it states in one paragraph that Romania reaffirms and will continue to support the position of the existence of one China, recognizes that the government of the People's Republic of China is the sole legitimate government that represents the entire China, and will not support Taiwan's accession to international organizations reserved to sovereign states. We consider that the above texts represent a commitment that it is sufficiently firm and clear to be considered a legal commitment. Moreover, could this question be raised whether the provision of such document could be invoked in front of a domestic court to preclude the legal effect of a document issued by the authorities of Taipei? As a matter of conclusion, I wish only to draw the attention upon the importance of this distinction and upon the fact that in the recent year the so-called politically binding documents have proliferated. In one way, they may be in the advantage of states, but it is very important for the courts and also for the negotiators to be fully aware of the possible legal consequences hidden in political documents. Thank you.